Yes, is it?
It is.
My lady, I'll start then with the bread and butter questions about the rules, if I may, and I'll try and take this reasonably briskly. If one starts, and I wasn't going to turn to 3117 either. For present purposes, all that matters is that it requires an application, and therefore an application notice. There's no special procedure. If one turns to Part 6, to see the structure of how this works, and I'm taking this from the white book, obviously. If we start on page 306, we see the general scope of Part 6, which is that it applies to the service of documents subject to, for present purposes, irrelevant provisos. In other words, this is a code which deals with the service of all documents. And then 6.2, interpretation, provides for that in this part, in other words, not necessarily everywhere else, but in this part, claim includes a petition and any application made before action or to commence proceedings, and claim form, claimant, and defendant are to be construed accordingly. And that, in my submission, is deliberately broad, and it is designed to capture the embarrassing fact that for all of my career, and no doubt everyone else's, we have had a tendency to call all sorts of what are essentially doing the same things by different names. Notices of motion, originating notices of motion. There used to be different practices in different divisions and so forth. But in my submission, what it's focusing on is that it's the commencement of the proceedings. It makes it a claim form. And that is significant because for the purposes of this part, what one is distinguishes it between the document which originates the process and which therefore, to English eyes, is actually what establishes the court's jurisdiction over the defendant, and other documents in the proceedings. That's the purpose of claim form. And there may be some circularity in a sense, but maybe it's none the worse for that. That in one sense, if one asks what are proceedings, the answer is they're things begun by a claim form. And if one asks what is a claim form, it's something which begins proceedings. And simply stopping there in relation to this application and focusing for the moment on Forsters, so not focusing for the moment on the trustees, if one said, are there proceedings on foot between my clients and Forsters, in my submission, every lawyer would say yes. And if you asked, how did those proceedings begin, the answer would be by the service of the application notice. And if you asked, was that the application which commenced proceedings, the answer would be yes. So that is the claim form. And if one then goes to two provisions which, in my submission, reinforce that conclusion. The first of those is Rule 638. And Rule 638 is dealing with service of documents other than the claim form permission. And it provides that unless paragraph 2 or 3 applies, where the permission of the court is required to serve the claim form out of the jurisdiction, the claimant must obtain permission to serve any other document in the proceedings out of the jurisdiction. Now, the significance of that is that's dealing with documents which are not a claim form, I accept that, but a different set of rules are applied effectively. You don't have to show for each of those documents that you fall within one of the heads of jurisdiction. Once the claim form has been served with permission, the court then gives permission under Rule 638 for the service of other documents. But if one goes to Rule 639, which is at page 387, that has a separate specific rule for the service of an application notice on a non-party to the proceedings. And where an application notice is to be served out of the jurisdiction. Now, first of all, note that is assuming that application notices do get served out of the jurisdiction on a person who is not a party to the proceedings. Various rules relating to jurisdictional applications, which for present purposes don't matter, don't apply. What that is telling you is that the rules envisage that application notices on non-parties may be treated as claim forms and therefore subject to the regime in the rules which deal with the service of claim forms, and it disapplies certain specific rules in relation to that. And that's a perfectly rational system, because in practical terms, if one is serving an application notice to join someone who is not party to the proceedings, that is a document which initiates the proceedings as far as that party is concerned, and therefore that is the document which the court's permission will be required if there's no rule which prevents one from needing permission.
And the proceedings may be limited in nature, but they are still proceedings.
They are proceedings. And proceedings is about as broad a word as one could choose to use for proceedings in court, in my submission. I'll deal with the specific cases in a moment, but on that point. But that then deals with the argument that there is no claim form, and therefore nothing in which the rules for service out can bite. That's, I think, the first submission. Now, I won't take you to it because it's, in a sense, water under the bridge, but you will see when you read Mrs. Justice Cockrell's decision in Nix that a rather ambitious argument was made that Rule 639 was, as it were, specifically designed to deal with this very kind of application. I don't make that submission. Rule 639 is perfectly general. All it shows you is that if you have an originating application notice, or an application notice which serves as originating process, the rules envisage that that will be treated as a claim form and permission sought accordingly. Now, that is the conclusion the judge reached, and in my submission, impeccably correct. Now, it follows from that in order to serve the claim form on the trustees, one has to fall within one of the heads of jurisdiction, and the only head on which we rely is Gateway 20 in Practice Direction 6b. And as far as the requirements to satisfy that are concerned, the first requirement is that there should be no other relevant provision, and it's not suggested that there is. The second is that there should be a statute which authorises or provides for, I'm trying to remember the exact words so that we get the very language. And I'm now not finding the thing. It's under an enactment which allows proceedings to be brought, and those proceedings are not covered by any of the other grounds referred to in this paragraph. So under an enactment which allows proceedings to be brought. So one then asks, and it's a slightly different question theoretically, though I give the same answer, is in principle, Section 34, an enactment, obviously yes. Does it allow proceedings to be brought? The answer is it does.
Well, that's the question. It allows proceedings in England and Wales.
That's a different question.
But that's a different one.
That's a different
It
question.
clearly is an enactment. It clearly allows proceedings to be brought in certain circumstances.
Exactly.
The only question is whether or not this is within it.
Exactly, and I'll come to that question in a moment. But at the moment, just focusing on the word proceedings, are these proceedings? Again, I give the same answer. Yes, Section 34 is an enactment which allows proceedings to be brought. Now, that then again is there's a slightly separate point about that which raises the AES case. Now, there are two cases, I think three cases actually, that my learned friend has relied on to say that these are not proceedings within the meaning of the practice direction in any event. The first of those is a case called GFN, which is referred to in his skeleton, but he didn't take you to orally, and I wasn't proposing to do so either. It was a case about whether somebody should be treated as a claimant, effectively, for the purposes of a security for costs jurisdiction in relation to some company proceedings. For what it's worth, it holds that you do that if, in substance, they are in that position. But it really will not help you in my submission on the meaning of the word proceedings. The second is, I think, an old 19th century case about whether you should set aside, if you want to set aside a consent decree, whether you should be bringing a fresh action or not. Again, it's not going to help you to decide the meaning of the word proceedings here. And the last, which he did refer to, so I'll take it very quickly, is the AES case. The question in that case was whether Section 37 of the Senior Courts Act, which is the section which gives the general power to grant an injunction, should be regarded as a section which allows proceedings to be brought. And my learned friend is right to say that in relation to that question, Lord Justice Ricks said he thought it was seriously arguable that it wasn't, and the other two members of this court expressed a more trenchant view that they thought it wasn't. But that is, in my submission, because if one understands how Section 37 is interpreted, bearing in mind Siskina and so forth, the power to grant an injunction is not a freestanding power to allow proceedings to be brought, it's a power to grant remedies in relation to proceedings which are brought. That is effectively what the court was saying. So it doesn't authorise the initiation of proceedings, it provides for remedial powers that the court will have in proceedings when they are brought. And if I just show you the relevant passages, those I think are, first of all, it's behind tab 22. Paragraph 126, that's Lord Justice Ricks. All of this is obiter, but that's not really important. Lord Justice Ricks said he would observe that although the words of paragraph 3.120 appear to have deliberately eschewed the former rule's particularity and opted for a catch-all provision, and that is a reference to the amendments which were made in 2009, I think. Previously, the equivalent rule listed statutes, and it stopped doing so. There must be a serious argument that Section 37 of the 1981 Act is not an enactment which allows proceedings to be brought, but more simply provides for a particular remedy within proceedings whose legal basis has to be found elsewhere. Now, that may well be right for Section 37, but it's not quite the same position. Well, it isn't at all the same position in my submission for Sections 33 and 34. Because
Mind you, there's not a lot of difference between them, is there? 37.3 and 34.
no, but
The words are the power of the High Court to grant an interlocutory injunction.
yes, but in a sense, to grant an interlocutory injunction is presupposing that there will be proceedings which are being brought.
Well, 37.1 says the High Court may by order grant an injunction.
Yes,
May by have power to order any person to disclose documents. It looks not unlike them,
It's not.
frankly.
Not unlike, but the thinking, in my submission, the thinking in the case is not, these are not proceedings. The thinking is that Section 37 is understood to be a power to set out powers which the court exercises in the course of proceedings which are already on foot.
Yeah, but
in relation
I'm
to
saying Section 34 looks the same. They are things you get in the course of another battle, not a separate war.
Well, that's true, except that Sections 33 and 34 are a bit different, because Section 34, it's satellite litigation, if I can put it that way. It's going to involve a person that is not party to any proceedings. And Section 33 is something where
Beforehand.
the proceedings, there may never be any other proceedings, because although proceedings must be likely, they don't necessarily have to be on foot. So that, in my submission, is the thinking in paragraph 126, and then I think the other paragraph is 192. Well, 192 is not is simply Lord Justice Wilson agreeing with Lord Justice Stanley Burnton, and then the actual decision, relevant paragraph in Lord Justice Stanley Burnton's judgment is at 207. And lastly, in my judgment, Section 37 of the Senior Courts Act, which confers power to grant injunctions in proceedings properly within the jurisdiction, is not an enactment under 6b. In the absence of another basis for jurisdiction, it is only if there is such an enactment that the court has power conferred by Section 37. Indeed, if it were otherwise, the Siskina would now be decided differently. And that's a reference to the fact that it's well established that for the purposes of Section 37, you must have a cause of action in order to found the injunction. In other words, the injunction is remedial rather than a freestanding and separate power. And that's true even in a sense for interlocutory injunctions. So the reasoning in that case is quite specific to Section 37 and does not, in my submission, and for the reasons the judge gave, undermine the natural and ordinary view that Section 33 and 34 do provide for proceedings. Which then takes us to the critical question, which is, well, does it allow proceedings to be brought against a person outside the jurisdiction? That's really the critical question. And that is the critical question, is established by the decision of this court in Orexin. And can I show your, my lady and my lords, that case? That is at tab 33. It was a case where permission was sought to serve a claim out under Section 423 of the Insolvency Act. And the judge had held that there was no power to do that, but that if there had been power, he would have exercised his discretion to do so. And in one of those sad moments for any advocate, the Court of Appeal decided he was wrong about both of those things, with the result that he had been right by accident. Now, there is some discussion of the principle of territoriality, which begins at paragraph 22. I don't want to make too much of this because the particular case involved a very different statute and very different circumstances, but it is at least a slightly extended discussion. It puts that principle, as you will see, and we'll turn to it in more detail in a moment, in slightly more nuanced terms than my learned friend does, because my learned friend tends to see the principle of territoriality, or extraterritoriality, as simply showing that a state must not take any action against those who are outside its borders at the time it takes that action. And actually, none of the cases go quite as far as that, for quite obvious reasons. That then is dealt with at paragraph 22. The general principle of international law is that that states make laws which apply to their own territory and no other, that they don't make laws outside their jurisdiction. There is therefore a presumption that Parliament will not seek to intervene in matters that are legitimately the concern of another country. They respect each other's sovereignty and the right of each country to legislate for matters within their boundaries. However, legislature does have power to make legislation that attaches significance to matters occurring outside the territory of which it is the law. This is in broad terms what we mean by the principle of territoriality. And the extent to which a law passed by Parliament attaches significance to matters occurring outside its own territory is a question of construction of the particular legislation. Sometimes that will be explicit, and then there's an example given, but few statutes are as explicit as this. And there's a discussion of a different example. And then turning to the particular matter at hand, at paragraph 32, Lord Justice Lewison, with whom Lord Justices Legate and Gross agreed, starts by saying that he would, given the extent of the court's powers under section 423, which were at that stage established by other cases, would a priori expect procedural rules to enable the court to exercise the powers. And then he quotes from Gateway 20. But then he says this: I think in paragraph 33 it must be implicit in this paragraph that the enactment in question must allow proceedings to be brought against persons not within England and Wales. Otherwise it would be of extraordinary width. And that's therefore the question that you're asking. Does the statute allow proceedings to be brought against persons within England and Wales? There's then a long discussion of the particular history of the gateways and how that interacted with various case law on section 423, but I wasn't going to take the court to. But there is then a relevant observation at paragraph 48. Well, actually, can I start at 47, because I'm going to pick some of these points up later. Where Lord Justice Lewin says the time has now come to say the court does have power. It doesn't accept the argument advanced by, for various reasons. And can I draw your attention particularly to these reasons? The second reason, the consequences of a claim coming within the gateway are radically different. Under the rules as they now are, the consequence of a claim coming within Gateway 20 will not necessarily result in service outside England and Wales. The court must still consider whether to grant permission. That is a strong pointer against implying any restrictions on the ordinary meaning of the gateway. The scope is to be construed in a neutral way. And then turns in paragraph 48 to a submission which was made by Mr. Gruder, who argued that in order to come within the gateway, the enactment in question must expressly authorise the beginning of proceedings outside England and Wales. That, he said, was the consequence of the words which allows proceedings to be brought. Moreover, if there were any doubts about the meaning of those words, the doubts should be resolved against the claimant in favour of the defendant. I do not accept this argument. First, it will be a rare statute that explicitly authorises proceedings to be brought against persons outside England and Wales. Second, as noted, Gateway 20 sits alongside CPR 633.3, and if Mr. Gruder's argument is right, the scope of Gateway 20 is entirely subsumed in that rule. Third, I do not accept that there is a significant difference for these purposes between a statute that explicitly provides for proceedings to be brought against persons outside England and Wales and one which on its true construction does that. And fourth, in that case, in the case of section 423, in Parliament Airways, it's held that on its face it does. And then he goes on to observe that the safeguards are important because in most cases, one is not dealing just with a legal right, one is dealing with an exercise of a discretion. Now, what that does at least show is that although this court thought it was implicit in Gateway 20 that the enactment in question must allow proceedings to be brought, it thought that that did not require express words of authorisation. It didn't treat the presumption against extraterritoriality, if I can put it that way, that highly. it thought it was ultimately a question of the true construction of the statute as a whole. Now, can I then turn to that question in principle? And I'm going to make certain observations in principle and then come back to the particular wording of section 34 and its context alongside section 33. The first is this, that it is naive to treat extraterritoriality and a very strong presumption against the court acting against people who or taking action in relation to people outside the jurisdiction as a very strong presumption which, as it were, is almost a trump card. The court routinely and for good reasons authorises proceedings to be taken against people who are outside the jurisdiction. And although it was at one stage fashionable to describe that as exorbitant, the modern approach is to say, no, we have to hold a more neutral position. And that indeed is the approach that the court was taking to the interpretation of the gateway in Orexim, and you will see the relevant quotations from two judgments of Lord Sumption set out at paragraphs 33 and 34. And in particular, of course, that from my perspective, towards the end of the first of those quotations from a bailiff, which I accept mustn't be regarded as unqualified by what was said in Brownlow. It should no longer be necessary to resort to the kind of muscular presumptions against service out which are implicit in adjectives like exorbitant, because litigation between residents of different states is a routine incident of modern commercial life.
Although immediately after deciding Abela
Yes.
in 2013, Lord Sumption decided Cox in 2014, applying the principle of territoriality.
Yes, and that's why I say you've got to be careful about not taking any of these things to an
You were about to say seriously.
It's not just that people can change their mind, it's that actually one is trying to hold a balance. And the balance that one is trying to hold in cases such as this is a balance between the unreasonable assertion of jurisdiction in circumstances where it really is an interference with sovereignty, and what is actually an unrealistic pretense that the modern world is not the modern world.
Well, it's reflecting the changes in practice.
Precisely similar.
It's also useful to remember that's why you just can't use words in the abstract. When you say words, you say them in a context.
You do.
And it's different to make people in Germany who've run people over subject to the Inheritance Act from arguably serving them with papers telling them there's a court claim against them. It all depends.
It does, my lord. And it depends also on... well, I would say one also has to be careful about using words like extraterritoriality. It's a single word which is actually embodying a very complicated set of concepts. And if one actually asks whether a given case involves extraterritoriality, really, cases have all sorts of contact with all sorts of different things. If you take this case, yes, the trustees are out of the jurisdiction, but the trust beneficiaries are in the jurisdiction. Some of the trust property is in the jurisdiction. The relevant transactions took place in the jurisdiction. The documents are held in the jurisdiction and by agents appointed within the jurisdiction. Now, to describe this as a case which involves extraterritoriality is to assume that extraterritorial has only one and one simple meaning. And what the cases suggest is actually it's more complicated than that. I'll come to that later. And that's, I'll interject this now without taking to the authorities. If you go back to the Alskany case that my learned friend cited to you this morning, what Lord Bingham, I think it was, referred to was talked about persons and matters outside the jurisdiction. It's not just as simple as saying you leave the country and some kind of magic wall is erected beyond which the court can't intervene. Which doesn't mean that it's not a relevant factor. I've already made the point, and it, I think, follows from that, that in this context, the presumption against extraterritorial effect, whatever that actually means, is not to be construed as requiring express words authorising proceedings to be brought outside England and Wales in order to fall within Gateway 20. The third point, I think I've also, in a sense, already made. It is relevant, at least relevant in this context, to consider the safeguards which are going to surround the power which is being exercised. There is a difference between something which operates automatically and says no smoking on the streets of Paris, and something which operates through a discretion of a public official, such as the Serious Fraud Office in the KBR case, or something which operates through the exercise of discretion by a High Court judge. Each of those processes has a different set of safeguards involved, or lack of safeguards, which can expect that tribunal to consider in the round all of the circumstances of the case which give it a connection or a lack of connection with this jurisdiction. And that is relevant when one asks whether, in principle, a provision can have even the most limited extraterritorial effect of sometimes applying to people who are out of the jurisdiction. And in the context of Section 34, therefore, one knows that Parliament knew that it would operate through at least two filters. The filter of the Rules Committee making the rules of court, which were going to enable applications to be made, and then the filter of a judge who was going to consider the applications when they were made. And that's a relevant factor in deciding what Parliament would have intended. My third point, and again I think I might already have made it in a way by reference to both Scamey and Orexin, is that territoriality is not simply a question of where is the person. It is also quite obviously a question of where is the conduct, and in the context of a case such as this, there might be a number of different sorts of conduct which are relevant to that. And the fifth point is that in the context specifically of documents, the territoriality principle has in fact on the authorities generally be seen more or as much as about where the documents are as about where the person is. And that, in my submission, is actually the true lesson, if I can put it that way, of McKinnon. There was no problem with personal jurisdiction in McKinnon. There was a branch of the bank in the jurisdiction fully amenable to the jurisdiction of the court. There was certainly no problem with it in the Grossman case, which is referred to in McKinnon, because it was, I think it was Barclays Bank, its head office was in the jurisdiction. It was not about the location of the person, it was about the location of the document. And what those cases really stand for is they say it's really unreasonable for an English court routinely, because they reserve the position in exceptional cases, but routinely to be making orders which relate to affairs, business transacted, and documents which are being held outside the jurisdiction. That's the territorial, insofar as territoriality comes into this kind of case, that seems to be where the focus lies. Now, my Lord Justice Mills asked this morning whether there was anything relevant in the Protection of Trading Interests Act. And I hadn't thought about it, but then there is.
That's a surprise.
Can I pass 3 copies of that? My learned friend already has one. I'll give him a few more. And if you look at section 2, section 2.1 provides that if it appears to the Secretary of State that a requirement has been or may be imposed on a person or persons in the United Kingdom to produce to any court, tribunal or authority of an overseas country any commercial document which is not within the territorial jurisdiction of that country, or furnish any commercial information to such court, tribunal or authority, or that any such authority has imposed or may impose a requirement on a person or persons in the United Kingdom to publish any such document or information. The Secretary of State may, if it appears to him that the requirement is inadmissible by virtue of subsection 2 or 3 below, give directions for prohibiting compliance with the requirement. Now, again, one's got to be a bit careful about taking something from a different statute. But insofar as a statute may show the sense that Parliament has of how territoriality works in a circumstance such as this, it is to be noted that it's not simply an imposition of a requirement on a person in the United Kingdom. It's an imposition of a requirement on that person to produce a document which is not within the territorial jurisdiction of that country. And that does seem to be at least a recognition that in this context, the territoriality jurisdiction is not concerned simply and solely with the location of the person producing the document, but also with the location of the document that's being produced.
That what section 4 is about.
Section 4 is dealing with requests, letters of request.
When would a request infringe the jurisdiction of the United Kingdom then?
I think it would infringe the jurisdiction if it was... Well, but it always, I don't know this answer, I'm sorry. I'm not going to try and give you an answer which would probably be a wrong answer. In practical terms, we take a rather narrow view of letters of request, and it's quite difficult to see in the light of a decision called Westinghouse, which was again about overbroad letters of request, that this would happen very often. Can I also pick up then at this point a question that my Lord Justice Mayles asked me this morning, or asked this morning generally, I think, about the significance of the property provision. And by that I mean that section 34 doesn't just provide for the disclosure of documents, it also provides in subsection 3 for various orders in relation to property. And my Lord said, well, that couldn't mean, could it, property outside the United Kingdom. Let's assume that that's right at the moment. It certainly seems intuitively sensible, but I haven't thought about it hard enough to be sure. But even so, does it follow that it couldn't make an order against a party outside the United Kingdom in relation to property inside the United Kingdom? So if somebody, suppose there was a allegedly old master painting or something which had been sold on to a third party and it was sitting in the oligarch's mansion, but the oligarch wasn't in the jurisdiction.
So that's the oligarch's mansion here, is it?
The oligarch's mansion here. Can the court make an order, the oligarch not being party to the proceedings, he's a third party, can the court make an order under subsection 3, or is it obliged to make a letter of request to the arbitrage court in Moscow, or whatever, to ask if the oligarch would be so good as to allow that to happen? In my submission, actually that is focusing again on the if my Lord is right, and intuitively it does seem sensible that this should be the case, that is limited territorially. It's limited territorially by reference to the whereabouts of the property, and not necessarily sensibly by reference to the whereabouts of the person who owns the property. And if it were otherwise, then you do get things which look at least, and I realise that this is always a difficult argument, because people can invent anything, but do look like odd lacunae. If the oligarch is outside the jurisdiction, then you can't make the order, but if he's in the jurisdiction at the time you bring it, you'll be able to serve it. the example of the doctor who has left the jurisdiction, the example of the person who routinely, but from outside the jurisdiction, uses agents here to transact business. If it is right that in those cases a hard guillotine falls and it becomes impossible to make the order, is the extraterritoriality principle really going to justify a result as strong as that? Or is it not more likely that Parliament intended that the words a party, or not a party to the proceedings, a person is actually the relevant word, just meant a person? And therefore it did contemplate the possibility that proceedings would be brought against people outside the United Kingdom, or outside England and Wales. And it's then a matter for the rules of court to decide whether that should happen, and for the judge to decide whether it's appropriate to make an order in that particular case. And why would that, one asks rhetorically, not amply satisfy legitimate concerns about sovereignty and territoriality?
On the 34 and the desire not to make orders as a matter of discretion that would interfere with sovereignty abroad, is 35(1) relevant at all? Or what's 35(1) about when it's returned?
I had imagined that 35(1) was trying to preserve some form of public interest immunity. I hadn't thought about it as being relevant to this. I suppose it could be invoked, but I think it's... So
it's not to do with the public interest of the sovereign state, and you shouldn't do it if you violate a sovereign state. It's not doing that then. It's more to do with something within the public interest in the UK.
I confess, without looking at the history of it, that is the assumption
What do you think?
that I had made. And
You
so
shouldn't grant order a document if it would violate public interest immunity, or something of that nature.
that was what I'd assumed,
Okay.
but I might be wrong about that. I don't think I can make the submission that it's directed at the particular topic
I
that your
just
lordship
wondered what it
is
was doing when I read it.
Now, it is, however, then significant to see Section 33 alongside Section 34 alongside Section 33, and I can jump off on this is my next point from your lordship's reference to Section 35. Section 35 suggests, and for what it's worth, there is authority which we've cited on our skeleton for the proposition as well, that Sections 33 and 34 form a related group of sections. Now, we know that in relation to Section 33, there is an extant judgment, but it predates Erexum, and therefore it didn't consider this point. But there's an extant judgment which says, yes, you can use Gateway 20.
It also didn't consider at all the principle of territoriality.
Exactly, and that's why I'm not relying on
it dealt only with the more technical points about claim and proceeding.
Precisely. Quite right. But in my submission, if we look at Section 33, there are very powerful reasons to think that Section 33 is not likely to be limited only to people who are within the jurisdiction. And for Section 33, it really does begin to come as high as saying it would defeat its purpose. Because Section 33 is envisaging application between two people, one of whom is the applicant, and the other is the person who appears to the court to be likely to be a party to subsequent proceedings in the court. Now, if that can't extend to people who are outside the jurisdiction, then even in cases where the subsequent proceedings are bound to be brought within the jurisdiction, either because they so plainly relate to something where there's going to be jurisdiction, I don't know, a road accident, for example, which has taken place here, take the facts of Cox but turn them on their head, or because there is, for example, a jurisdiction clause which requires the proceeding to be brought.
Would you then need Gateway 20?
Well, you wouldn't in relation, well, you might or might not in relation to Gateway 20, because the jurisdiction clause might not be wide enough to extend to a pre-action application, because it wouldn't be an action actually it's procedural rather than substantive. So there might be an argument about that. But
would it matter? Because that's the rule about service of documents. and this is really about which things you can bring proceedings for in the first place.
Yeah, that's true, my lord. But I think the point let me remove the jurisdiction clause from because it's not necessary to go there. Let's suppose a case where it's quite plain that the action, if it's brought, would be likely to be brought here, but the defendant is currently outside the jurisdiction. If my learned friend is right and what he says about section 34 applies to section 33, then Gateway 20 would not apply. And you'd have to be in the old position that you'd have to begin your action first before you could get your disclosure. But only if the defendant was outside the jurisdiction. It seems, I submit, much more likely that in section 33, the relevant question that the court should be asking is simply, is it likely that an action will be brought in this court? In other words, is it likely that permission to serve out would be given to bring an action in this court? And if it would be, then it shouldn't matter where the person that's going to give the disclosure is. Section 33 would apply. So although Ms. Newman did not consider this in OBEX, if that's right, then there are some quite powerful reasons to think that section 33 should apply to a person outside the jurisdiction. Now, of course, it is possible that where the word a person is used in section 33.2 and a person is used in section 34.2, they have different territorial ambits. Possible, but in my submission, unlikely, in two provisions which are mirrors and part of a single coherent whole. And staying then with the language of the statute for the moment, the last point that we make is that there's that we say, but maybe it's a wash, that the fact that section 33 and 34 do not contain any limitation, as one sees, for example, in section 36, is at least some indication that no limitation was intended.
Well, what Mr. O'Leary says is 36 shows that when they wanted to have things extending outside England and Wales, they put in express words to that effect. But you would say, but that's because of the nature of the subject matter. That's actually to bring people back to this country.
Yeah.
And that's very different from what the kind of circumstances in which you would accept it would be appropriate to exercise the discretion.
I think it's probable that there's a historical reason for this. Subpoena was originally a writ of the court, and therefore it ran within the jurisdiction of the court. Section 36, I believe, the main purpose of Section 36 is actually, as its heading suggests, that the subpoena runs not just in the jurisdiction of the court, but in the whole of the United Kingdom. But it does make it clear that it doesn't run outside the United Kingdom. That's, as it were, also part of Section 36. But in the end, I'm not sure how much weight one can attach to comparing different provisions, particularly in something like the Senior Courts Act, which is a bit of a kind of accretion over time of different provisions which have been inserted for different reasons.
I mean, the Section 36 is dealing with subpoenas where everybody knows, and it's always been the case, they don't operate outside the jurisdiction.
Precisely.
And as you say, it extends it to other jurisdictions within the United Kingdom. When the earlier incarnation of Sections 33 and 34 were brought in, it was recommended by the Wynne Committee, who said that it was effectively to accelerate the subpoena process, so that you didn't have to wait until you subpoenaed somebody to bring the documents at trial.
Yes.
You could do it at an earlier stage, either pre-action against the defendant or post-commencement of action against a non-party.
Yes.
And if that's the right way of viewing it, that it's all part of accelerating subpoenas, doesn't that tend against your argument?
Well, if it were simply that, then that might. But I'm anticipating the argument I'm going to make in due course, or a point I'm going to make in due course. It's not actually coincident with the subpoena, because the whole point about the disclosure is that it is, if one thinks about a subpoena, even after the civil procedure rules, it requires, for example, some of the things that one expects in a letter of request, such as a specific identification of the very specific document. Section 34 and Rule 317 are wider. Sorry, 3117. 31 is in the disclosure section of the CPR by design, and they are designed to produce. They go broader than subpoenas. It's a point which Mrs. Justice Cockrell, as she then wasn't, makes in chapter 4 of her book. And I think that she makes the point 402 that it's a similar jurisdiction to the summons to produce documents, but the jurisdiction also effectively abolishes the mere witness rule and also undertakes to a great extent the approach to documentary witness summons as letters of request. And then if you look at 405, she says at the end of that paragraph in that page that there is no doubt that jurisdiction is considerably wider than that which pertained under the old subpoena ducis tecum regime, and that the test to be applied is easily to satisfy. So they're not actually, they're not, that may be the origin of it, but they're not precisely analogous.
Mr. Stanley, if we're dealing with the language of Section 34 and indeed Section 33,
Yes.
and this isn't directly following on from points you've been addressing, it is those phrases in accordance with rules of court and as may be specified in the rules. You find it in 34
Yes,
too.
ma'am.
Is there an argument, and one sees it in that quote from Lord Sumption that Lord Justice Lewison made in Erexim, that those rules are designed to reflect the changes of practice, to reflect the way lives are being led, particularly commercial practice is being progressed.
Yes.
And therefore, there is an argument that Section 34 is silent as to certain matters to allow for flexibility within the rules.
Precisely, my lady. And it wasn't the point I was on, but it was the next point I was going
And then
to.
I should have just kept quiet.
No. It's always good when the question is a question which one can answer immediately because one was going to go. Absolutely. The last point I want to make is if one is asking, and this is the question, was it intended that sections 33 and 34 should allow an action to be made against someone else, against someone out of the jurisdiction? I think my learned friend does have to say that if there had been a rule made which expressly authorised an action on someone outside the jurisdiction, that rule would have been ultra vires. I think he has got to say that, because he's got to say that a person means a person in the jurisdiction, and therefore that a rule outside would be ultra vires. Now, he's got to do that in the face of three things. Firstly, the breadth of 35.2, which is broad.
35 to
35.2. Rules of court may make provision for the circumstances in which an order under section 33 or 34 will be made. And any rules making such provision may include such incidental, supplementary and consequential provisions as the rule-making authority may consider necessary or expedient. With subsection 3, which is relevant insofar as it shows that where Parliament wanted to qualify that, they could do so, because they expressly qualified it in relation to something like something as narrow as costs. And most importantly, with the conclusions that the House of Lords reached in Masri about the overall reach of the rule-making power. Now, Masri, of course, is a case where both people can get something from it. On the one hand, it shows an example of the court interpreting, but a specific provision, and very much in the context of its particular legislative history. A provision as not requiring or not permitting service out of the jurisdiction. But even that it shows how specific things have got to be, because you've got I think it's Turner and Seagull, and then Masery, which sits between Turner and Seagull. And therefore you can see that there are circumstances in which the court accepted that you could have such power. But none of that really touches anything that my lady or my lords have to decide, because it's all dealing with a different set of rules. What in my submission does have relevance, as the learned judge thought, is the conclusion which is reached in paragraph 14, in the light of what is said in paragraph 13. What paragraph 13 does is it makes the point that there has been progressively an expansion of jurisdiction by the Rules Committee into ever fresh areas. And that in those circumstances it would not be contrary to the general rulemaking power for the court even to go so far as to make a provision which required somebody to come into the jurisdiction to answer questions, which is on the face of it a much more intrusive thing. Now that is, in my submission, relevant, because if what Parliament has done in sections 33 and 34, read with section 35, is to entrust those questions to the rulemaking process, and if the rulemaking process has as its background that it is intended to be flexible, including flexible as to how territoriality is to be applied, that does tell against the assumption that a person was actually intended to mean a person in the jurisdiction.
Was it section 84 that was the rulemaking power at the time this act was passed?
I don't know the answer to that question. I think my learned, I think we think it might.
No, 84 was something different by the looks of it.
Well, also it depends what you mean by when the Act was passed, because sections 33 and 34 have, as my Lord Justice Males has pointed out, been amended from time to time, and they don't take the form that they took originally in 1981.
Well, no, they took the limitation on personal injuries out, but it may not matter, because it may be that section 34 means rules made under whatever act allows them to make,
Yes,
and may be broad enough to encompass a later 1997 act, which gives extraterritorial rulemaking power,
yes,
even if the original act didn't. But it would be better for your case if even the original 1981 rulemaking power had within it the prospect of extraterritorial rules, if you follow me.
Well, that it undoubtedly did, because it was Order 11 which used to regulate the service out. And in those days, the heads of service out, which were from time to time amended, though not probably as often as they needed to be, were in Order 11. The modern practice, they've been stuffed into a practice direction, which some people, I think Professor Briggs in particular, takes objection to. But I mean, the overall trend has been, it's always been a matter which is regulated by the court's rules, not for the most part statutory. Now, my learned friend's answer to that is then to say, oh, well, yes, but you've still got to ask the question of whether the rules do so provide. I accept that. You do have to ask that question. But in the context of this case, that doesn't help him, because the rules do so provide by Gateway 20 if the Act allows them to do so effectively. Because the question you're asking under a Rexham is, does the Act allow proceedings to be brought? And it does. And so if one answers that question, then the rules have so provided. Now, there are two remaining points on extraterritoriality that I wanted to pick up. Otherwise, I think I've dealt with the relevant authorities and the points I wanted to make. The first was some concern about enforcement and how relevant enforcement is. I don't say that enforcement may not sometimes be relevant to the question of whether something has extraterritorial effect, but one must be careful these courts regularly make orders against people outside the jurisdiction, which it may, if push comes to shove, be more or less difficult to enforce.
Actually, where the documents are within the jurisdiction, it occurs to me that you could quite easily enforce it by a Masiniaki Tolmi order.
Well, I was going to say, exactly. One can imagine a number of ways in which one could enforce it if push came to shove, if the documents are in the jurisdiction. But what can't be assumed is that merely because a person is outside the jurisdiction, the order will be unenforceable. That doesn't seem likely. That is a slight difference with, one might think, with, for example, an actual witness summons to attend at a particular place in a particular time, where you might say, well, if somebody won't come from Luxembourg on Wednesday morning, what are we actually supposed to do? We know what we can do if they're in the jurisdiction. We can issue a warrant if necessary. But if they're in Luxembourg, what do we do? A bit different with documents. If they're in the jurisdiction, there are a number of ways in which one could do it, in practical terms. So that doesn't, it's probably not a very weighty argument anyway, because one would normally like to think that if an order is worth making, it's worth making and trying to enforce. And one would also normally like to think that most people comply with this sort of order. And in fact, that's not just guesswork, it's actual practical experience. But in the context of the type of situation that we're dealing with here, one can't actually say that merely because the person is outside the jurisdiction, the order will not be practically enforceable. It's likely that it would be. And the last point that I wanted to make, which I think arose in a number of cases, so it doesn't really, a number of situations, doesn't quite belong anywhere. In a way, I've already addressed it in answering my Lord Justice Mail's question about the origins of Section 34 in, as it were, early subpoenas. But it isn't, in my submission, right to treat 3117 as simply an analogous to a domestic version of letters of request. The true analogy domestically to letters of request is actually the witness summons to produce particular documents, or the witness summons to actually come and give evidence. And letters of request are obviously used for both of those things. Rule 3117 and Section 34 serve a wider purpose. They go more broadly than either of those things. And that's the point that Mrs. Justice Cockrell made in her book. Now, if you look at the whole pattern of ways in which you can obtain evidence, you'll find it's a patchwork. And although it's always right, certainly as a matter of discretion, to consider, well, is the use of this procedure appropriate in circumstances where you aren't or you couldn't use a different procedure? Certainly relevant as a matter of discretion. It goes in my submission too far to say, well, there must always be one and one only route by which particular evidence could be obtained, and any alternative route must be illegitimate. It's not the approach that we take. So 3117, you don't say, well, you could use a witness summons, so why are you using 3117?
It has been a factor, though, both in KBR and also in Tucker, that there were other procedures specifically dealing with the outside the jurisdiction.
I'm not saying it's not a factor. It's a factor, but it's not a decisive factor. It's particularly not as decisive a factor where actually the letter of request procedure, although it's well established, it doesn't cover the whole ground. It's not as elaborate, for example, as the procedures which were being considered in KBR. And I was going to turn then finally, before I leave the topic of extraterritorial effect, to KBR and Masri. Masri, I think I've probably already dealt with and said anything that I want to say about. KBR, I think, comment. That is at tab 34. And the points I wanted to make are, first of all, it is important to read what the judges in the Supreme Court said in the context of the statute and the issue that they had to consider. the issue that they had to consider is set out in paragraph 1. The order which was made by the SFO director was to require KBR, a US company, to collate material held abroad and produce it to the SFO under criminal penalty for failing to do so. KBR did not have a fixed place of business in the United Kingdom and had never carried on business in the United Kingdom. And it sought to quash the notice on the ground that it doesn't have an extraterritorial effect. It contends that there was no jurisdiction for the SFO to issue the notice requiring the production of material held by it outside the UK. That is what had then led to the application for judicial review. And the relevant ground was ground 1, paragraph 18, that the notice was ultra vires as it requested material held outside the jurisdiction from a company incorporated in the United States of America. And if you look at the question, the point of law certified by the Divisional Court, that's at paragraph 20. The question was, does section 2.3 of the Act permit the director of the SFO to require a person to produce information held outside England and Wales? Now, I accept that if you read on in the judgment, the extraterritoriality is often referred to by reference to the place where the person was, but of course that it remains, in my submission, relevant to consider, or to read what is being said in the light of the particular questions which were being posed. The statutory provisions in that case, you will find at paragraph 14. And they were broad statutory provisions which required simply a notice in writing from the director which required the production, a person to produce to the director the documents which were specified. Now, one argument, the last point I wanted to, now that obviously means that, yeah, it is effectively a different case. I'm not saying that what it says about extraterritoriality is not of interest. It obviously is. But one should be cautious about assuming that it was answering the question here. It was a different statutory scheme in the context, and a different factual context in particular, because the documents, there was no question about documents being here. The last relevant part of this case that I wanted the court to see was the way they dealt with a subsidiary argument that was made on behalf of the director at paragraphs 64 and 65. And the subsidiary argument was effectively to say, well, yes, it would go too far to simply say that the statute can allow you, entitle you to require anyone to produce anything. But could you not have a reading of the Act that the power could be used to produce documents outside the jurisdiction by a foreign company, subject to an implied requirement that there was a sufficient connection between the company and the jurisdiction? And that suggestion was rejected, and a contrast was made between the position in other areas. So in Paramount, Sir Donald Nichols drew attention to the fact that the unlimited territorial application of section 221 of the 1986 Act led to the conclusion that there was very broad powers. But he pointed out that the court doesn't exercise it unless there is a sufficient connection. Similar view has been taken of sections 133 and 238 in Re Seagull and Re Paramount. In this way, the courts, and remember, Re Seagull is an example of that. That's the one where directors are required to attend to, or officers are required to attend to give explanations to inspectors. The courts have interpreted the 1986 Act as conferring the widest powers, but have provided a safeguard against the exorbitant exercise of those powers in the form of judicial discretion. This approach, however, provides no basis for the implication of a similar limitation in Section 2.3 of the 1987 Act. It was only necessary under the 86 Act because such a broad reading of the power was compelled by the language, purpose, and context of the provisions. In my view, for reasons already stated, there is no warrant for such a broad reading of Section 2.3 of the 1987 Act. Now, I can draw nothing from that because I can't say there's anything in this statute which compels such a reading. In particular, such a reading would be inconsistent with parliamentary intention as evidenced in the scheme and history of the legislation. Secondly, Section 2.3 confers a power not on a court, but on the SFO. As a result, there is no scope here for limiting the operation of a broad interpretation or safeguarding against exorbitant claims of jurisdiction by the exercise of judicial discretion. Now, I can rely on that because I can say that is a contrast with Section 33 and Section 34, where judicial discretion and rulemaking discretion run through it like black ball runs through the rock. And thirdly, a statutory rule which empowers the SFO to demand production of documents by foreigners outside the jurisdiction when there is a sufficient connection between the addressee and the jurisdiction, without defining what would constitute such a connection, would be inherently uncertain. Well, that of course is in a sense still true here, but it's qualified by the existence of the judicial discretion. And then fourthly, they say no basis for an implication of a limitation. Now, of course, I don't need to say that there's an implied limitation here. I simply need to say that the existence of those safeguards and the existence of those discretionary factors are a reason for not necessarily construing the statute in the way that the statute was being construed in KBR.
And I can see that a phrase such as sufficient connection gives rise to problems of uncertainty.
Yes.
But at any rate, a certain amount of the reasoning in KBR would seem to support a view that you could construe a statute about documents as extending to documents here, but not abroad. But you don't seem to like that approach.
You could do. I'm not. I mean, if that's, I'm advocating. I'm not saying that that construction is impossible, and on that construction we would still be entitled to succeed. But because this particular case, it would be a statute which allowed this application to be made. But really, I think I'm putting my argument on a slightly simpler basis. What Erexim is asking is, does this statute contemplate proceedings being brought effectively ever against a person outside the jurisdiction? If it doesn't, then there will never be a reason to allow service out. If it does, then the safeguards to decide whether service out should be permitted or not are the safeguards under the rules, namely that the court has a discretion to exercise to decide whether it will be, whether there's a sufficiently strong case, which will bring into effect, into play all of these factors, whether England is the appropriate forum, and the residual discretion. And if that's right, then you've answered the Erexim question. Does the statute allow this to be brought by people outside the jurisdiction? You've answered it yes. Any further substantive jurisdictional limitation would be relevant at the later stage.
Well, your argument, as I understand it, focuses on the words a person,
yes,
and says that means a person anywhere in the world.
Exactly.
Whereas the alternative, which I'm exploring and doing no more than that, is that would be to focus on the words document, or indeed property in the other subsection, and say, do they mean documents wherever they are, property wherever it is, or do they refer to documents and property here?
Well, I think we're in violent agreement in a sense, but we're answering different questions. I'm asking the question whether the statute allows proceedings to be brought. And in that context, the relevant question is, does it allow proceedings to be brought against people outside the jurisdiction? I'm suggesting you answer that question by saying, does it ever allow that? And if it does, then that's answered that question.
It might be a different question.
may
Does it
still-
allow bring proceedings? Does it allow the application for an order against somebody outside the jurisdiction in respect to property?
In
outside
respect
the
to property.
jurisdiction?
And
It all
that-
depends on what question you
I
ask.
agree. And the truth is, my lord, you could answer that question either in interpreting the gateway or at the discretionary stage, where you would say, well, if the position is that these documents are outside the jurisdiction, we would never make that order, or even we're not entitled to make that order, because on a true construction, the statute would not envisage it, at which point you would refuse permission on that basis.
Well, the difference between jurisdiction and discretion is that once you get jurisdiction, then people are brought here to argue about discretion. And when it's a discretionary question, there's usually something to argue about.
True.
And therefore, you get people being brought here, even if they then manage to get themselves sent away again.
True, except that if it were clear that the documents were outside the jurisdiction, and the court's view were that the court would never be appropriate to make an order in relation to documents outside the jurisdiction, then although formally it's a discretionary matter, the answer is the application to serve out would always fail, because the application would be bound to fail. I think the one case that I'm hesitating over is, what if it were not apparent where the documents were held? They might be in the jurisdiction, they might be out of the jurisdiction. Would one say under those circumstances no power, or would one say yes, there is power to allow the service, and we will sort that out when we come to the substantive hearing, when it turns out where the documents are actually being held?
There might be really unusual circumstances. If you think of southern Iraq after the invasion, the former government of Iraq had been removed. There wasn't yet a government in Iraq, and the British were occupying forces of southern Iraq.
Yeah.
If somebody had done something terrible to a British person in London, immediately fled to southern Iraq with the documents that proved this, photographs that showed the injuries and so on, you can see extreme circumstances where there might be a reason for saying, well, the British people are in authority there, they're able to do it, and that chap has fled there and it's a British action. So you can never say never, but it's pretty unlikely. Or if, I don't know, somebody from Russia fled to Donetsk or something, that's a bad example, or Crimea or something.
Maybe that kind of example, which is behind my slight resistance to the way that my lord is putting it, and my slight tendency to say, no, if it's a simpler question, you're just asking, does the statute allow claims to be brought against persons outside the UK, the jurisdiction? Answer, yes. Now you're in Gateway 20 and you're in discretion territory. Because, as my lord says, there are circumstances are multifarious, and sometimes discretion is an advantage. But, my lord, different people have a different view on that, because the different view sometimes is taken, well, no, actually, discretion gets you into a world of complication, and it's better to have a hard-edged rule. For present purposes, I don't actually mind how the rule is adopted, so long as it's clear that at least sometimes, and those would certainly be in circumstances where the documents are in the jurisdiction, it is appropriate to bring a claim under through Gateway 20, and that's all I have to show.
And if you look at the wording of 34.2, because it is about the words in an act, you said a person, and you've just got to read that as what it is, who is not a party to the proceedings, and who appears to the court to be likely to have in his possession, custody or power any documents. It's given quite a degree of specificity. He's got to be likely to have in his possession, custody or power any documents which are relevant. And it doesn't add, and also they must be ones that are in England and Wales.
Well, that's true, but it's absolutely right. But I think we're at a stage where we're almost arguing about how one reflects what is not a principle which is really much in debate, in the sense that I'm not arguing that one would expect the courts to end up making orders against people in relation to documents which they hold outside the jurisdiction.
No, but we are arguing about the words in the
We are.
statute. The question is whether a person is qualified in line 3, but the documents in line 5 are not qualified. So I don't think we can quite say, oh, it's terribly complicated, but it'll all come out in the wash. We are trying to give effect to words in an act.
So the submission that I make in rejecting my Lord Justice Nails's way of looking at it is to say that the only question is, does a person include a person outside the jurisdiction? If yes, then Gateway is satisfied, Gateway 20 is satisfied, and the rest is discretion. That's the submission that I make. But I don't think it would kill my case if I can put it that way, if one took a slightly more hard-edged approach. But essentially, for the reasons that my Lord Justice Lewis has given, that is the submission that I make. I was going to move on now to the question of discretion. Would that be a convenient moment to take a break for the shorthand writing?
Can you just allow me 1 moment?
Of course.
Should we do say to 3:30?
Certainly. Oh my God, I did know, and when he said it, but I couldn't now remember it. But I think the easier thing, I thought of two different routes. You can just get the authorization, the court can sign an authorization necessary. So if your clients refuse to authorize it, you just get a master to sign it. I don't think.
Do you know what the name of the case is? Which is the type of order?
Which
is a type of enforcement order? If they don't comply, make this kind of order. No. Good.
Yeah.
There's some relief in not knowing.
I certainly obtained a master signs.
Yeah.
Yeah.
Yeah, I mean that's what I would do, I think. But I mean, I suppose you'd get a search order as well, stuff.
For sure. All sorts of things.
Actually,
Yeah.
I don't think enforcing would be tough for documents in the jurisdiction.
Yeah. It's about, yes, well, it's not the best another time.
Because I went to that, you weren't fully full of it, but that's exactly the evolution of laws, which a man's then described in Massery. So I think I did answer. Yes, you did.
There was only one moment when you were talking about KKR. You took it to all the random passages and then you forgot to make a submission. Everyone was waiting for you to say something.
Oh, I'm sorry.
After about a minute, you said, and here's my submission. It's the submission everyone expected. But you,
Yeah.
you were obviously pondering about your shopping list this evening.
All right, Mr. Stanley. Now you're moving on to ground 2, discretion.
I'm moving on to ground 2. I think I've already said that we accept that an element in practical terms of the exercise of discretion in a case such as this will be whether there is such insufficient connection with the jurisdiction that the court would not appropriately exercise its power to order the documents to be produced. And it doesn't much matter whether that is put in terms of saying it's an aspect of the merits test, because if the case is clearly one where the documents won't be produced or won't be ordered to be produced, permission shouldn't be given on that ground. Or whether it is said it's an aspect of the forum non conveniens test. Because although England is clearly the most appropriate forum to decide what documents are required for an English action, I think what would be said is that it's not the most appropriate forum to decide that, where the documents have absolutely no connection with England and the person has no connection with England, and someone else, namely the Cyprus courts with a letter of request or something of that sort, are the more appropriate to address that point.
Yes, I think one of the cases we were shown had a paragraph which said much the same, didn't it? That it didn't matter which way the point was put.
It doesn't matter which way one does it. So I accept that it can be looked at. My submission on it is essentially that once one crosses, in this case, the threshold of saying that there was potentially jurisdiction, there's nothing that has been said which amounts to or comes close to saying that the judge made any error of principle in relation to that. Which is, of course, in this court, the relevant question. And if one looks at the grounds of appeal, just to identify the points which are raised, ground A is saying that the judge erred by relying on the fact that copies of the documents are electronically accessible by Forsters LLP who are within the jurisdiction to justify serving the appellants out of the jurisdiction. Well, that couldn't be an irrelevant consideration that the documents are in Forster's possession. And one's got to be a little bit careful about electronically accessible. I don't think there's any evidence that the documents are out of the jurisdiction but just happen to be electronically accessible. They are Forster's documents.
Well, if you look at 102, it's a number of things together. It's not just they happen to be here. They're here for a purpose. They're here for giving advice on transactions in England, and the underlying litigation relates to those transactions. Yes. It's a shorthand for all these documents have got England stamped all over them. It's like a stick of rock, really. England goes through them.
But in the main point is, in my submission, if one is identifying A as an irrelevant consideration that the judge should have put out of his mind, it plainly isn't. It's a relevant consideration. That he erred by reasoning that the appellant should be before the court when the application against Forsters is determined as a justification for permitting service out of the jurisdiction. Again, it cannot, in my submission, be an irrelevant consideration in considering whether the English court is an appropriate forum. I think, well, here at least is somewhere where all of the relevant parties will be before the court in a single hearing. And that's classic forum non-relevant consideration. And he erred by relying on the assertion that it may take longer to use the letter of request regime under the Hague Convention. Well, again, it's not a weighty point, I think, in the judge's actual conclusion. He's dealing effectively with a submission that it was an irrelevant point, and he says that it's a relevant factor. He's not saying it's decisive, but it's a relevant factor. And again, in my submission, the judge could not be faulted for regarding whether an application to get documents could be made in time for a trial as at least a relevant factor.
But he says at the end of 107 he'd have reached the same decision without it anyway.
Exactly. So putting all of those things together, the answer to ground 2, I'm afraid, is a boring answer, which is the judge was exercising a discretion. None of the grounds that have been identified indicate any error of principle in the way that he exercised his discretion. In fact, obviously, I would go further and say if you look at the facts of this case, you can well understand why he did exercise his discretion that way. But that's not really the question. So that's the answer as far as ground 2 is concerned. If there was jurisdiction, there is no error of principle whatsoever in the way that the judge has exercised his discretion in relation to it. And then on ground 3...
just before you leave discretion, on paragraph 106,
yes, my lord.
the judge records an acknowledgement by you that the fact that the letter of request route would have required more specificity is a matter which can be taken account
Yes.
when considering the merits. Do you accept that, in principle,
I do.
an order ought not to be made under CPR 3117, which could not be made in relation to a letter of request?
No, I didn't go as far as that.
No.
And
I'm just trying to see
deliberately
exactly,
don't accept that.
I'm just trying to see exactly
No, not at all.
where your point does go.
That wasn't what I said. Because in fact, the fact that an order couldn't be made may be a reason why 3117 may still be the appropriate thing to do if you're dealing with, for example, documents which are in the jurisdiction. What I accepted is that it's a factor that the court, looking at how one particular remedial regime sits alongside, or procedural regime sits alongside other procedural regimes, must always be something the court is entitled to take into consideration. And if the court formed the view, looking at the case as a whole, well, this was plainly a case which should have been done by a letter of request. And it's only being done in this way in order to avoid the requirements of the letter of request regime, which was effectively the position in Nix. In Nix, you had documents which were outside the jurisdiction. They couldn't be specified. There were a whole raft of reasons in Nix why that application should be refused. So I accepted it as a factor, but I didn't say it was decisive. And the judges, I think, absolutely correctly recorded my concession, which I stand by. Alternative service. Now, on this, my learned friend, I didn't address the judge on alternative service. He didn't need me to, but I will address you. It's much the same point. The principles, the relevant principles, are most conveniently set out in Mr. Justice Foxton's judgment in M against N, which my learned friend referred to. It's at tab 35. And that pulls together a lot of other authorities, which I'm afraid have also crept, as they always do, into the table, but you don't need them. And the relevant points to note for present purposes are that it is accepted, or generally accepted, that in a Hague Convention case, so in a case where the state in which the service is to be carried out is a Hague Convention country, that is, as it were, requires something more than just a reason. And that in cases where the country in question has stated its objection to service otherwise than through the designated authority, which I think is not this case, even more is required.
I think we did see or get told that there was some objection by Cyprus, but that was under the evidence.
I think that was under the Evidence Convention. Under the Evidence Convention, they've entered the objection, which says they won't give pre-trial disc.
Yeah, you're allowed to do that. Yeah, that's what, yes, okay.
I think that's right. And then in the end, if you look at the factors that are set, or the examples which are given in paragraph 9 by Mr. Justice Fox, what they all really show is that although it is generally accepted that the mere fact that it takes longer to serve under the Hague Convention is not itself a reason to grant alternative service, if there is, in the particular proceedings, some positive reason why you need to go faster, that can be a good reason. So examples are interfering with directions for an existing trial, or an expedited trial being appropriate. There's a reason why speed matters in the particular case. Now, think that if one, again, one is looking here for an error of principle in relation to a case management decision of Judge Hook, which for good measure was the same case management decision that His Honour Judge Pelling had taken to start with. And if one looks at the grounds which are advanced in the grounds of appeal, there seem to be two. The first of those is that the judge shouldn't have made his order because Mr. Gorbachev's application against Forster's is not an existing trial. Now, that really is, with great respect, actually, it doesn't sound like I'm having much respect for it. That just is a very pedantic and silly way of reading examples of cases where courts have found that there is a good reason. That it can't make a difference whether it's a trial or something else which is going to be disrupted.
9.1 says existing trial or require claims which there is good reason to be heard together. And if you're writing the claim against Foster and the claim against the trustees are claims that the judge said should be heard together, isn't it?
But besides which, it's also a false point because there is an existing trial. There's a trial that should take place in January 2023, the actual trial of this action. Now, sanctions, officy and sanctions permitting, but that's the current timetable. So there are real reasons why one needs to get on with this.
But the reason why he wanted to get on with it was to have the Foster's application and this application heard together, wasn't it?
Together, exactly.
Yeah, and that's the second part, or the last part of the sentence. It has nothing to do with the trial in January, I don't think, is it?
No, well, I think it's all related because they want to have those applications heard together and in good time before the trial.
But perhaps your broader point is that in this part of the case, at least, we're not construing a statute.
No.
We're simply looking to see whether there's either a good reason or a very good reason.
Precisely.
Something like that.
And secondly, it said that merely avoiding delay or inconvenience is not a good reason. Well, there's nothing in the judge's judgment which suggests that he thought that merely avoiding delay or inconvenience was a good reason. He gave much better and more specific reasons. Now, I think this morning, my learned friend added, and then my Lord Justice Mayles decided it was his best point, a ground that's not actually a ground of appeal, that the judge ignored the fact.
No, it is there. Any delay or inconvenience is a problem with Mr. Gorbachev's own making.
Oh, I see. That's right. Well, okay, in that case, but that the judge must have had in mind because he refers to the history of paragraphs 13 to 14. And he knew perfectly well that what had happened was we made the application against Forster's. They spent quite a long time, or we first of all wrote to them, and they spent quite a long time taking instructions from the trustees. Or I think the trustees don't like them to be called instructions. They like them to be called consultation with the trustees as the owners of the document. But I doubt there's much difference in how the telephone call sounds. Then they decided that they weren't going to give us the documents, so we issued the application. And then the point emerged, and His Honour Judge Pelling suggested that the way of dealing with it was to join the trustees. Now,
When did they tell you they weren't going to give them?
That they weren't going to give us the documents. I think it's obviously before August 2021, which is when we issued the application for non-party disclosure.
Right.
Someone behind me may be able to give you a precise date.
Yes. Oh, that's probably good enough.
So it's a case where it's a case management decision in which two judges thought that this alternative service was appropriate. The learned judge obviously thought it was very clearly appropriate because I wasn't called on. And there's no error of principle in relation to that. And it's not a decision that it would be appropriate for this court to interfere. So my lady, my lords, that deals with the standard grounds of appeal. On the cost point, one point has occurred to me, which is that there's going to have to be a decision about the cost of this appeal in any event, regardless of the court's decision. Now, if that decision is against me, then the cost point will become moot, one anticipates. If that decision is in my favour, then we're effectively going to have the same argument about what weight is to be given to the fact that this is an application which is pendant on an application under 3117, which has some special cost rules, no doubt in the context of your own decision on costs. Now, I don't know whether that affects how you want to proceed with that, but both of those points did occur to me.
Well, that's it. I mean, it does seem sensible not to deal with it now,
Yes.
if I may say so, speaking for myself. The first of your reasons seems a valid one, if that's the case. If however, the appeal fails, there may be a distinct argument about whether somebody is entitled not only to the benefit of a first shot at first instance, but also to an appeal,
Yes.
a free ride, which is a slightly different question, but that doesn't detract from my view, at any rate, that we should defer the question of permission to appeal until we know where the appeal is going.
Yes, I accept those two separate ones are separate points, but they're likely to require one to travel much of the same really interesting ground. And I wasn't going to say, obviously, anything about stay, because I think it's, at the moment, it's fallen away. And again, we can probably deal with it in consequentials if we need to.
Well, maybe, but we've managed to get the appeal in quickly, but that doesn't mean that the members of the court are going to be able to produce you a quick judgment, and you may not get one before you would need to be doing things, I'm not quite sure what your timetable is, but doing things for the purpose of the applications in the commercial court.
Right. Well,
We have discussed the matter, and nothing can be precise, but we think it unlikely that there will be a judgment or judgments before the start of next term.
Right. Well, if that is the case, then I think that both the evidence and the actual application are likely to come on before this court gives its judgment. So let me address the question of what one does about stay. My submissions are as follows. It would obviously not be right for the trustees to be required to hand over documents if the only basis on which they're required to do that is an application which it turns out the court did not have jurisdiction to make. And that is a prejudice which they would suffer, which I suppose costs couldn't really realistically be necessarily said to be an adequate compensation. But so long as that order is not, as it were, actually executed, everything else is actually just cost. It is putting in evidence and then appearing and arguing.
Well, if I was still a commercial judge, I might have a view about whether I should be asked to have a hearing and prepare a judgment
Yes.
on something which was potentially hypothetical.
Yes.
If I was going to have the hearing, I'd want to be in a position to prepare the judgment before I forgot all about it.
Yes. Well, I don't think even preparing the judgment wouldn't necessarily mean that the documents had to be handed over. It'd be, what I was going to say is we could always say that regardless of the outcome, we would stay enforcement of effectively whatever decision the commercial court makes. And the other possibility is to say, well, it is actually rather a matter. I mean, is it a matter for the commercial court? If your lordships and my lady said, no, it's not a case for a stay. There's no need to stay the proceedings for this. Mr. Stanley says, and I do say, that I am perfectly content to say that if the decision is that the documents are handed over, only because the trustees are parties, that we would not seek to have those documents handed over until after this court has given its judgment, so that the documents would remain secure, which they are in the hands of Forsters, but they wouldn't be given to us, so that the only balance would be costs. Then it might be that the right thing for this court to do would be to leave that to the commercial court. And if my lord is right, and the commercial court says, well, no, if we're going to get a Court of Appeal judgment nearly at the beginning of term, we're willing to wait till then. That would be one thing. And if the court thought, well, no, actually, we want to get on with this, because there's after all got to be the application against Forsters anyway, that would be a matter for the commercial court to decide.
When is the hearing due?
27th of September.
Because the Forsters application will have to take place anyway, and if they decide to grant an order against Forsters, this appeal becomes interesting but redundant.
That's true. Or, yes, that's right.
It'll become academic on the 27th of September. Yes, the commercial judge takes a few days. It'll be a race of judgments.
Yes, I mean, the counter-argument, which the commercial court judge would say is, well, there's also this quite interesting, difficult point about whether under 3117, a lot of old law about whether you can have subpoena ducis tecum against agents is going to have to be looked at. But if Forster's is free, if the trustees are part of the application, that falls away. Now, I suspect that something along those lines might have been what was going through His Honour Judge Pelling's mind when he said to me, Mr. Stanley, would you think, please, about whether you should be joining the trustees? Because that point is irrelevant if the trustees are parties. So I'm not suggesting it's satisfactory, but it may be that what this court has to decide is it satisfactory and we need to decide what happens, or is it slightly unsatisfactory, but I think we should leave it to the commercial court to decide how it wants to organise the procedure, given that we can say that we won't give our judgment, we won't be in a position to give our judgment before a certain date, and given that Mr. Stanley makes it clear that he is willing to undertake not to enforce the judgment if it is just against Foster, so as to get the documents, if it may turn out that I'm not entitled to.
Do you know, Mr. Stanley, my background has nothing to do with commercial law, but as a QB judge, if I was doing a hearing on the 27th of September, knowing that the Court of Appeal was going to hand down a relevant judgment in about a week,
Yes.
I'm not sure I'd be best pleased.
No. Well, I certainly would need to go back to the commercial court to decide if that was the right thing to do. I think all I'm saying is it's a question for you to decide. Do you want to take that decision for them and say, no, okay, we're going to actually stay the proceedings and we'll have to go back to the commercial court to refix it? Or do you want us to go back to the commercial court and say, actually, what we should be doing now is fixing this hearing, either keeping it or more likely fixing it for a date when we're going to have the judgment?
Yeah.
I'm a bit worried that just having a stay is just going to kick stuff off into the long grass, and knowing how the commercial court lists look, if we wait till October to then go back to the court and say the stay has now been listed, we'd like a date.
What's the estimate, assuming both parties are there, or perhaps it's shorter if both parties are there, but what's the estimate?
I think it's a day, and my recollection is a day.
Chances of getting adjourning from the 27th of September and getting it in at a later date.
I mean, there are two aspects, aren't there? One is the service of evidence, which has got to take place at the moment by early September for the trustees and then mid-September for you.
Yes.
I mean, unless anybody is going to be prejudiced, and Mr. O'Leary will tell us about that, other than in costs and yet further disruption to holidays, it may be that could go ahead, but the real issue is whether there's any point in the hearing going ahead before you've got a judgment when you'll get one shortly after.
Yes, exactly. And although I don't dissent from the thing that that's the real issue, I guess in one way the question is just, is that something that you want to decide, or do you want to say go back to the commercial court, tell them the position, and let them decide how they want to handle that?
Well, we couldn't stay the Foster's application, could we? We've got no basis to stay the Foster's application. It's nothing to do with us.
No, but I think, again, I want to be realistic.
If we stay the other one, we probably would.
We will be going back to the commercial court and saying,
there's no point in us coming out with
there's
half
no point.
of our...
Probably the most practical thing to do is to try to make sure that the applications are listed for a time when this court's judgment is available.
Yeah.
That would be the ideal, I think, from a case management perspective.
And if anything this court can do, obviously the applications would be made to adjourn by the parties, but it could be made clear, certainly as far as I'm concerned, that they have the support of this court. The sense would be that the hearing should take place after judgment's been handed down.
Yes. I've just been handed a note, which I can't quite believe, which says that the next one-day hearing available is March 2023.
Gosh, that can't be right, can it?
Availability for one-day hearings on the website are from March 2023, but it may be that something can be done to improve that.
Well, that's why I was suggesting whether the support of the court could.
Exactly. The other thing you should know about, I don't think it affects this, is that because of the off-seat position, we are, as it were, that there's been a delay in the service of witness statements that is being still looked at, and there is always the possibility that if the sanctions position makes it really impossible, there may be changes to the trial date. But at the moment, that hasn't happened.
But that only affects Mr. Guriev, not you, is that right?
The sanctions only directly affect Mr. Guriev. They may affect us indirectly in terms of funding, but we're not sanctioned. Obviously, from this application's point of view, if this trial disappeared, then there would be more legroom. But neither party wants the trial to adjourn. That was the last information. It's really just a question of seeing if one can prod OFSI into actually taking a decision on the licence.
Right. Well, obviously, we'll hear from Mr. O'Leary, but anything more you want to say to the court?
No, my lady.
Mr. James, we've read your skeleton argument. We see that the position taken on behalf of the second respondent is one of neutrality. Is there anything you want to say?
I have no submissions to add to that. There are just two very minor clarifications from what's transpired so far today.
Yes.
First of all, my Lord Justice Lewis did state in the question to my learned friend that this was a case in which all the transactions to which the documents relate, i.e. the third-party disclosure application, are relevant to this jurisdiction. I just wanted to clarify that's not quite Force's understanding. Obviously, what is sought is our entire file up to 2014, and that file relates to Cypriot trusts and Cypriot trustees. And there are transactions, for example, I believe the option, which is in many ways central to this case as well, that does not directly relate to this jurisdiction. There is the purchase of the property or Medale, which is in this jurisdiction.
I was just reading from 102 of Mr. Justice Jacob's judgment. They related to transactions to take place in the jurisdiction, but there may be some transactions which are outside the jurisdiction. So not all the documents relate to UK transactions.
Precisely. It's often the case that English trust lawyers are asked to advise on a whole range of things which don't directly relate to the jurisdiction, and that's certainly the case here. The second brief point of clarification I wanted to make was just in relation to the previous submission to Mr. Stanley about when Forsters stated they were not able to make the disclosure. The date given was August 2021. It was
Before August 2021.
Yes, I've got the reference if the court needs it in the bundle. It was June 2021, where we made clear that because we weren't able to disclose the entire of our file without the consent of our clients, and Mr. Gorbachev wasn't willing to compromise on that the application would have to be made. And the letter setting out that position is at supplementary bundle, page 290. So it was June 2021.
Very much indeed.
Unless I can be of any other assistance.
Yep. Okay, sir. Thank you very much indeed, Mr. James. Yes, Mr. O'Leary.
Thank you, my lady. First, I think, deal with the last point first, the question of a stay.
Yes.
We would say that it's not appropriate to require the trustees to participate in a process when it may be the decision of this court that they haven't been properly served and that the court has no jurisdiction over them. And that extends to their entire participation in the process. It's not just enforcement, it's potentially making an order which they would then have to comply with. It's requiring them to decide whether or not to appear and be taken to by other courts, not this court, but by other courts perhaps to have submitted to the English jurisdiction. And that goes for putting in evidence as well. So if I hear what you've said about supporting an application to the commercial court, that timetable be set down after judgment is given in this appeal. So we would take the position that that should be a short timetable for evidence and the hearing, not just for the hearing. No,
forgive me. I'm sure I phrased it clumsily. I was concerned that if you lose the hearing date on the 27th of September, one is brought in as soon as possible. And I know in other divisions, if the court can assist just getting an earlier hearing date, which is relevant given the March 23 date that's been put before the court. I wasn't taking it any further than that.
I'm terribly sorry. It's me
No,
who's
I'm
being
sure it's
misunderstood.
Mr. O'Leary.
Not at all. I wasn't intending to ascribe to you that latter point about evidence. That was my add-on to what your ladyship has said. I think your ladyship has said we should have a hearing of the application as soon as possible thereafter. My submission in addition was that our position would be that that should include a process for evidence as well. It's a relatively short period between, on the current timetable, from the 2nd of September, when we are supposed to give evidence, until the 27th, is it, when the hearing is supposed to take place. It's unlikely to make a significant difference if that same timetable is repeated. If it's going to be a matter of submission to the commercial court, rather than decided by this court, then we can make that submission ourselves, I suppose, to that court. So I suppose in some ways I'm just putting down a marker if that's the process that's to take place.
You said at one point that you need to decide whether to appear in the proceedings. In an ordinary jurisdiction case, that may be a relevant consideration, but it's not a practical possibility in this case that the trustees would simply not appear, because then the English court would have decided that it had jurisdiction over them, and it would either make the order or not as it thought fit. And if it made the order, then Fosters would produce them, the documents. So it's not a practical possibility, is it, that the trustees, if they lose this appeal, will simply draw up their skirts and disappear back to Cyprus?
I think there are a number of factors that may go into that decision, my lord, and I don't have instructions to make submissions on that point, I'm afraid. I think that it's entirely possible that the trustees may consider that they don't wish to appear and be taken to have participated in the substantive process, but as I say, I don't have instructions on what they would actually do. Right. So, that being the case, I have only 2 points of reply. First point goes to 2 different submissions that my learned friend made. At the start of his submissions, he said there's something of a tension or a paradox in our case, in that we say, logically, it's the logic of our case that even if the court theoretically has jurisdiction under Section 34 to make an order against persons outside the jurisdiction, the structure of the gateways and the meaning of proceedings in the gateways would mean that there is no such, that service out of an order of an application under Section 34 still cannot be made. He described that as a paradox. Second relevant submission, I'm going to explain why the point actually goes the other way. But first of all, there's a second relevant submission, which is answered by the same point that I'll make, which is that Section 33, at least, must have extraterritorial application, because it would subvert its purpose if an order for pre-action disclosure could not be made against a party outside the jurisdiction. And if it didn't have extraterritorial scope, then it wouldn't fall within Gateway 20, because it wouldn't be an enactment that allows proceedings to be brought against persons outside the jurisdiction. And so that can't be, he said. That would really undermine the entire purpose of Section 33, and so it simply can't be that there isn't jurisdiction under Section 33 and under Gateway 20 in respect of Section 33. Now, the reason why that's not a good point is because Gateway 20, which is at the heart of both of those submissions, was amended in 2008. And until that time, the relevant gateway had applied by reference only to specified enactments. It didn't apply to any enactment which allowed proceedings to be brought against a person outside the jurisdiction. It applied to a list of specified enactments. And the Senior Courts Act was not on that list of enactments. And so, however you look at it, prior to 2008, there was no jurisdiction to serve a party outside the jurisdiction on an application under Section 33 or an application under Section 34. So in fact, the paradox is the other way, that on my learned friend's case, there was this hidden jurisdiction, this hidden extraterritorial application of both of those sections, lurking in the Senior Courts Act, waiting for an amendment to the gateway. Now, that is, of course, possible. The Court of Appeal in Erexum contemplates the possibility that there may be such enactments. There may be legislation which lacked a gateway but had extraterritorial scope until 2008. That's logically possible.
Was the list of statutes in the CPR practice direction that was actually in the rules of court or the practice directions?
Both.
In both of them.
Yes.
So if the statute means jurisdiction as defined by the rules, there wouldn't be anything unusual, would there? Because if they change the rules to reflect changing practices, my lady suggested, then from 2008 the world had changed a bit.
I'm sorry. I mean, I'm going to need to take that slightly more slowly.
If Section 34 says there's nothing in principle wrong with jurisdiction, read people outside the jurisdiction, whether or not there is to be such jurisdiction is to be specified in the rules. And if in 2008 the rules were changed because, as my lady said, the world had changed and things needed to be changed, all that was happening then was that the rules was giving implementation to a possibility that already existed.
Thank you, my lord. I do understand. There are two responses to that. The first is that I was really responding to my learned friend's point, which is there's a paradox in my case. I suggest it's the other way around. It would be surprising if several years, since at least 1970 in the case of Section 34, and at least 1981 in respect to Section 33, although that may have a...
No, they both came in together.
Oh, did they in the Administration of Justice Act?
Yes.
Okay. I had looked at Section 34 and not the history of Section 33. For years, there is this extraterritorial scope that Parliament has intended, but no gateway, and no mechanism of using that scope. That would be the surprise. It's not that it's impossible, but that would be the surprise. Now, as to the second point, which is, well, what if Parliament didn't have an immediate intention to allow applications to be made against persons outside the jurisdiction, but recognised with some prescience that times may change, and left it open to the Rules Committee to make such an application. And there are two responses to that second point, the first of which is the case that I promised I would bring copies of, which is, Mr. Stratton is going to hand up. It's the case of Holmes and Bangladesh Biman Corporation. We'll come back to that. The second point is that even if that was the intention of Parliament, we will say that that shows that references to rulemaking powers are subject to the same construction, the same presumption against extraterritoriality. But the second point is that even if that was the intention of Parliament, to leave open the possibility that the rulemaking committee could make a rule allowing such an application to be made outside the jurisdiction. As I have said, no such order has been made. And Gateway 20 is not such a rule. Gateway 20 does not purport to allow Section 34 orders to be made against persons outside the jurisdiction. It asks whether or not Section 34 allows such an order to be made against persons outside the jurisdiction. If the answer to that question is, well, it depends whether a rule has subsequently been made by the Rule Committee that does allow that, well, no such rule has been implemented. And so that may be something that happens in the future, but is not something that has happened so far. Insofar as this case is helpful, obviously I very much accept the point that I'm sure will be made, that the context is not the same. But the reasoning is nevertheless instructive, I would submit, which is this related to a apparently broad statutory power for delegated legislation to be made to specify where the Carriage by Air Act applied. And so orders in council could be made allowing delegated legislation in relation to carriage by air of such description as may be specified in the order. And the simple point is that, in fact, an order was actually made, unlike in this case, an order had actually been made setting out various extraterritorial effects and applications of that underlying act. And at 1126 of the judgment of Lord Bridge, from just above the paragraph in the middle of the page, from above D to F, he says that the judge and the Court of Appeal didn't apply their minds to the right question. They construed the order and found that it led them to the startling conclusion that the Act did have extraterritorial application. But the problem was that they should have construed the rulemaking power, effectively, as being limited. So I do not say that that is conclusive, but I say that it shows that the rulemaking references to in such circumstances as may be set out in rules or in an order is subject to exactly the same principles of construction that I've set out in relation to the section 34. There is one other point that I think it's proper to raise to assist the court. I don't know whether it's likely to be particularly decisive, but I think I ought to just address one point that my learned friend made. In his argument that an application notice served on a non-party can be a claim, and that there's something in Rule 6.39 which tells you that, I think some care is required in drawing inferences from Rule 6.39. Now, if that submission is put as broadly as it was, that some application notices on non-parties can be claims, then that's not controversial, because it's quite clear from the definition in Rule 6.2 that some applications, such as an application pre-action, can be claims. Some application notices can be claims. I would just like to say that I'm not sure that it's safe to draw that inference from 6.39. 6.39 simply says that where such an application notice is to be served out of the jurisdiction on a person who is not party to the proceedings, relevant previous sections, which I accept relate to claims, do not apply. Now, that may be, as I say, anodyne, because it may refer to things like applications for pre-action disclosure or applications for third-party costs orders, in which case, fair enough. However, the commentary to the White Book suggests that where an application notice is a claim, then it doesn't fall within 6.39. That's in the second paragraph. It says, the rule applies where an application notice is served out of the jurisdiction on a non-party. It does not apply where the application notice is for pre-action relief, as in Part 6. Such a notice is, by definition, a claim form. See Rule 6.2c. I don't have a submission as to whether that commentary is right or wrong. It doesn't. My only point is that if it's right, then it doesn't tell you whether or not a particular application notice is a claim form, because some application notices are and some application notices aren't. And if it's wrong, it also doesn't tell you whether a particular application notice, such as the one here, is a claim form, because we already know that some application notices are claim forms. So on my submission, the real point is whether that commentary is right or wrong. So Rule 6.39 tells you nothing about whether any particular application notice is or is not a claim form. Unless there's anything further, that's my reply.
Well, as you're on your feet, a couple of practical matters. Let's just go back to the stay point and your comments upon the filing of evidence. Am I right in thinking that the filing of evidence, you're referring to the order of Jacobs J, dated the 25th of July. You'll find it at tab 8 of the core bundle. I know he made an earlier order when he dismissed the application, the jurisdiction application.
I am referring to that order of the 22nd of July.
And it's really paragraph 5, yeah?
Yes.
So what exactly are you asking, Mr. O'Leary?
Well, what I would propose is that once we know when the judgment in this appeal is likely to be handed down, a short timetable is set down for the filing of evidence and the hearing of the application, be it against Forsters or be it against Forsters and the trustees.
But why though? Because the evidence has got to go in at some stage anyway. Why delay the evidence I know you say it looks as if they're taking part and so on. Everybody knows the position. They don't agree with this order, full stop. But surely it's better to have the evidence ready.
And also, I don't see the point of the longer you delay asking for a later hearing, the further away the hearing is going to be. You need to get on with it.
Well, it may
I
be
think
that we
someone
do
wants
need.
to speak to you, Mr. O'Leary.
We of course don't want to delay the hearing. We want to put off the evidence until after we know what's going to happen in this case. If it's likely that judgment is expected around the start of the next term, then setting out a timetable starting shortly after that is something that can be done now. We don't have to wait necessarily if, you know...
But why do you want to put off the evidence? Because if the evidence is in, then it'll make it much easier to get a timetable, because you're only having to think about one thing, which is a date, rather than a period of weeks or days to do evidence and then a date.
Solely because we say it's not appropriate to require the appellants to take part in the substantive part of that application in circumstances where the court may conclude that the appellants haven't been validly served, or that the court does not have jurisdiction at all over them. That would have been inappropriate. The court would have made us participate in a process where the court's jurisdiction had not actually been engaged.
And separately, the point you raised at the outset, which was your ground for the cost point, as we anticipated, there isn't time to deal with it today. It seemed to me that the point made by Mr. Stanley has force.
I was going to make exactly the same point.
Good.
I completely agree.
Right, well that shortened that one, hasn't it? Mm-hmm. All right, we're going to rise now. Thank you.
Oh, I see. I misunderstood. It is falling apart. I could feel that happening. Actually. Thank you. Try and knot them down with shoelaces. It might be better off getting Tom to do it. Actually, I've seen your shoelaces.
Do you have any?
What's that?
The license?
When you say that, I used to do it that way, and Andrew Ayres told me to do it the other way.
No, always wrong. There are three schools of thoughts of bands. There are people with elastic bands. Totally unacceptable.
That's not a school of thought.
And then there's the tie at the back and the tie at the back. No, I mean the tie at the back and the tie at the front.
I used to do it, and then some people were rather patronising. They said it was very sweet the way you tie your bag.
I was taught to do it that way by Charles McCulloch, who was an evil, evil, evil Queen's Bench judge. And so I reckon that if he did it, he couldn't possibly be regarded as anything other than absolutely hard ass.
I will seek
And
out.
it was also him who put it out.
What does that?
Because you can put that in your mouth, and it helps you time.
Oh, I see. But then over time.
Otherwise you're trying to do it. Otherwise you're trying to do it under there, and it doesn't work.
Even if I'm convinced about the tying in front, I'm not going to start putting them in my mouth.
I learned that from him too. Anyway, what I can't do is keep my wig on properly today.
Well, if Mr. Stratton can manage with everything that he's got under his wing, then...
This is the shortest my hair's been.
He had a haircut. After he was taken on, he went and had a haircut, proving
Was
everyone
that
wrong.
3 years ago?
No.
So you're just jealous.
That's true. You know, you're not wrong. Beaten up.
I know.
Goodness.
Which noble will be warned by that point? Except by Matt, London with the gagged cow.
Explain.
I'll just go dungeon. Happens and cheese.
Conrad one has all sorts of facilities.
You're a witness bar. You might be cross-examined about this later.
Isn't there pointy like the signs? Sort of thing. Wolf grabbing is something. I don't know. When I came in, wolf grabbing is rules. There must be something.
It's distinguishing between the upstairs people and the downstairs. No, we don't own the upstairs. No, we don't occupy the
So you're heading
upstairs.
back tonight?
No.
3 a.m. tomorrow morning. I have to
3 a.m.
Oh yes, there's another one.
It's going to be brutal.
Flight at 7.
It's crazy. Try to tell you that.
2 hours of traffic. In fact, actually called by you're expecting the other one.
Have you? Do they put you right?
Well,
Do they say we've got
they said, oh, yeah, you've got the wrong.
That's kind of. We always fear that they say, no, he's not available anymore. Would you like Mr. Jones instead? I think the worst story was against my colleague, as though they were exactly. Yeah, I do the opposite with him when we're in the cafe and they say, would your friend like coffee as well? I say, it's not my friend, my pupil.
You wear the same things? Anything at some point? You can buy very little.
You're being very vivacious.
I'll do anything I'm not. Are you still pupil?
Yes?
For another 27 days.
Roll.
Under no circumstances ever.
Mr. O'Leary, the appellant's application for a stay is refused. The evidence which was required to be submitted in paragraph 5 of the order of Mr. Justice Jacob dated the 25th of July 2022 is to stand. That is subject to 2 caveats. Firstly, by submitting the evidence, the trustees are not submitting to the jurisdiction of this court. And secondly, that the trustees are to keep a record of their costs of preparing the evidence, which, if this appeal succeeds, will be recoverable from the claimant on an indemnity basis. We are also ordering there to be a joint application by the parties to invite the Commercial Court to adjourn the hearing from the 27th of September to the first available date at the end of October. And if between certainly you, Mr. O'Leary, if you're going to stay in this country, and Mr. Stanley, that order can be agreed between you. If you want to send it to my clerk, I look at it and I can approve it. All right?
Thank you very much.
Well, as you will have gathered, we've given the court a considerable amount to think about, and we will. It is unlikely, as we've said, that there will be a draft of judgments before the start of term. I'm grateful to the parties who have appeared here today for giving to my clerk the list of all those to whom the judgment can be sent or at least seen, because I doubt there's anyone in this court who hasn't read the judgment of the Master of the Rolls and Counsel General of Wales and the effect of any breaches of the embargo, namely a contempt of court. And I hope it goes without saying that the court expects all to strictly observe the terms of the embargo when it comes. You don't need me to say that when the judgments come through, they are for amending of typographical errors and nothing more than that. But I cannot end this hearing without, again, thanking everyone who has done a great deal of work in a very short space of time to ensure that the court has been well assisted in its deliberations today. It's clear teams worked well and hard, and we're grateful. Thank you very much.
All right.